Hey folks, welcome back to the channel. Today's proceedings began with a dispute over a $25,000 insurance payout, but things quickly spiraled into chaos. The defendant ignored court orders, pocketing the money without consulting his soon-to-be ex-spouse. But the real drama? That came from the attorneys, who turned the courtroom into their own personal battleground, with accusations of gaslighting, stalling, and petty bickering. Let's see how this simple financial dispute became a full-blown catfight.
Okay, let's go ahead and go on the record in Roller versus Roller, file 23-17793-DM. We have several matters set for today. First, we have, in order to show cause, we have a objection to the submission of the plaintiff's interim order with regard to return of insurance proceeds, and then also an objection to an ex parte order for return of insurance proceeds. We have with us the plaintiff's attorney, Ms. Whitman, and the plaintiff, Ms. Roller. The defense's attorney, Ms. Boyd, is here as well, as is the defendant. Mr. Waldenmeyer is here as well. The court's had a chance to review the matters that have been filed. Let's go ahead and take up the objection issues first. I have had a chance to review the objection issue. Did either party get a transcript? I know that one was requested. There was a transcript, Ms. Whitman?
Yes, we did receive the transcript and I sent it to Miss Boyd last week upon receipt.
All right, and based on that transcript, and I don't have it in the file, which unfortunately is not coming up. I don't have availability to it right now. Why don't you go ahead and advise me, Ms. Boyd, since these are your objections, as to what the transcript states.
And honestly, Your Honor, I believe that I received the transcript late last week. I was spending time with family and my daughter. I've not had an opportunity to review it before the holiday. So Ms. Whitman pointed out, though, two lines specifically. I believe it was at the end of the hearing where you mentioned wanting the insurance proceeds provided to her. Again, at that time, though, I want to remind the court, I was not actually on Zoom. I was called in. I didn't have power or internet. So I was having difficulty hearing. That's why we didn't go through with the hearing. I have an IOLTA statement showing that my client has provided me with those funds. I can turn those funds over to Miss Whitman, if that's what the court would prefer. Again, it was my understanding at the end of the hearing, as I stated to Miss Whitman, that essentially the court just did not want my client to have access to those funds. And I informed her, I believe it was the morning, sorry, I want to get my dates correct here. I believe it was the morning of December 5th that I apologize, maybe it was the 4th, that I had those funds in my possession. My client transferred those funds, and the IOLTA statement shows those funds were transferred into they were wire transferred into our IOLTA account on the 3rd.
And the amount again is $4,000 and change, if I remember. Can you get me the amount?
Yes, so I can bring $4,480.84. I do believe that total is also in part due to a $25 fee charged by Chase for the wire transfer that was charged on the defendant's end. Our bank also charged a $10 fee, but nonetheless, I do have that IOLTA statement that I can provide to counsel and the court.
Right.
And again, I'm happy.
Let's see if we can finish this particular issue. Ms. Whitman, are you seeking a transfer of those IOLTA funds into your IOLTA account?
Yes, I am, Your Honor. I sent the transcript as soon as it was received on December 20th. I sent it to Ms. Boyd at 12:52 p.m. I have the transcript and we can share screen it if you want to see it, Your Honor.
You can tell me what it says. You're an officer of the court.
Yep. It says, well, I wrote to Sarah or Ms. Boyd and said, attached for your review and information is the court transcript from December 2nd, 2024 hearing. I call your attention to Judge Elsenheimer's directive at the end for the remaining insurance funds to be deposited into the WFL trust account. Court. So regardless, Ms. Boyd, I'm going to grant your request. I'm going to require you place whatever is left in terms of the $25,000 payment in Ms. Whitman's client trust account within 48 hours. Any questions from you, Ms. Boyd? Ms. Boyd, no, Your Honor. Thank you. And
All
then
right, based on that, the transfer does need to occur. The court's already ruled on this matter. There's no reason for us to retread. And those funds, Ms. Boyd, should be transferred to Ms. Whitman's IOLTA account. Frankly, I'm agnostic as to which of your IOLTA accounts have the money, but I do understand that there can be individual concerns with regard to your clients. The money is necessarily must be put in an IOLTA account. Ms. Whitman's is fine. We'll transfer the money over there. That needs to be done within 48 hours.
Your Honor, I'm sorry, before you move on, since it is Friday afternoon, is it okay? And our bank is obviously, I don't have access to it since
Business
I am
hours.
not. I just want to make sure.
Next week.
Okay.
We're fine. 48 business hours. Okay. All right. Let's go ahead then and wrap up the issue of objections to the order with regard to insurance proceeds and placement of the funds in escrow. It does appear that the objection is inappropriate. The order should indicate that the funds go into the Whitman IOLTA account. As a result, I'm going to overrule that objection. I will execute the order that I think Ms. Whitman filed as well. All right, let's go ahead and proceed to the additional matters. And that is the objection to the ex parte order regarding return of the insurance proceeds. And I think, Ms. Whitman, you also filed recently a motion with regard to the status of or an accounting for the remainder of those proceeds. I did have a chance to review that. I did have a chance to review that. It isn't noticed up today, but we are talking about the same issue here. So to the extent Ms. Boyd has read it, perhaps we can address it. If not, then we'll take it up in due course. But Ms. Whitman, I think this is, I'm sorry, is this Ms. Boyd's objection or Ms. Whitman's objection? The file isn't coming up.
It's my objection to the ex parte order, Your Honor. And honestly, I actually just when I was reviewing the file, trying to get my head wrapped around the things that have been filed in the last 2 months or so, I actually just noticed on the docket that Ms. Whitman did file this motion regarding an accounting of the insurance proceeds. So I have not had a chance to really thoroughly review it, let alone file a response, because I do have a response to that. But I also understand that the matters are related. But to that end, I guess as far as the objection is concerned, my concern, and I guess this relates to the show cause issue as well, is Miss Whitman attaches to her motion correspondence between her and I, which number one, frankly, I think is completely inappropriate because those are things in which her and I are trying to resolve issues. And instead, what Miss Whitman tends to do is use those to throw them in opposing counsel's face, as she loves to do when she files motions. But nonetheless, in her response, attached to those emails are her statements stating that her client agreed that payments to 911 Restoration and to Roto-Rooter, almost totaling the amount of $10,000, are expenses that her client agreed should be paid and could be paid from the insurance monies. That is what is so frustrating, is that she files a motion requesting the court enter an immediate ex parte order making Chase Bank put a hold on $25,000 that doesn't exist at that point, because her client and my client have both agreed that there's appropriate expenses because of the flood that need to be paid. Ms. Whitman filed that motion knowing there was not $25,000 unavailable insurance proceeds money because there were expenses agreed upon by the parties that could be paid. She certifies, and her client certifies in this certified motion emergency show cause, as well as an emergency order, stating that the $25,000 must be secured, knowing there's not $25,000. That's unethical, Your Honor. And it is really surprising to me that Ms. Whitman would file such a motion in that manner. It's really frustrating too, because I continue to have to come in here, spend my client's money, spend my time trying to defend, constantly trying to defend against all of these motions. And frankly, it's just a bombardment. It doesn't matter how I respond to Ms. Whitman, what I respond to Ms. Whitman, she will file a motion anyway. Because no matter what I provide her, it won't be good enough. I provided her receipts showing that my client paid these expenses, and she files a motion anyway. She files a motion to show cause. In response to her letter, she puts in her motion that she sent me an emergency letter on November 9th to make it look like I didn't respond for 5 days. November 9th is a Saturday. I'm sorry I wasn't working Saturday and Sunday. 2 business days later, I do respond though. This is all just an attempt to overwhelm, frankly, me and my client with more pleadings and constant bombardment of almost legal harassment. It's all the time. And if you don't respond to her when she demands, then she threatens you with motions. So it doesn't matter what I provide or how I provide it. Miss Whitman comes at me again, wanting more. It's not good enough. I need more. I need different. Again, I send receipts showing where money has gone to pay for some of this. She agrees those were expenses her client agrees to. Not good enough. Nope. Now I need a full accounting. Frankly, Your Honor, I find it's just a constant waste of time and energy. She's trying to show cause my client for violations of the UCC, for violations of Chase Bank's policy. Those aren't appropriate show cause issues. I'm so confused as to the direction she's trying to take this in, and then she's trying to drag me under with her, and I don't appreciate it. And I'm exhausted, frankly, by her attempts to do so.
All right. Thank you, Ms. Boyd. Ms. Whitman, I'd really like to focus in on the issue at hand, which is the identification of the location of the $25,000 that came from the insurance company. But given the statement that was made by Ms. Boyd, I'm going to allow you some time to go ahead and respond. You may do so.
Your Honor, I take significant offense at being accused of being unethical and all of the other things that she's claiming. I'm not interested in retaliating against her. I believe that, and all the correspondence between us will show that I've been nothing but respectful and patient with regard to her and the things that we've been trying to work out. The reality is, and we can put all of our communications into evidence. The only one who has been rude is Ms. Boyd. Now, the reality is that when we filed our motion, Ms. Boyd had not responded. I had emailed her and said, hey, this money just disappeared. We're trying to find it. Can you please get back to me as soon as you can? Her response was, I have a young child. I don't have time to get back to you. I'm preparing for an abuse and neglect case, and that's happening the rest of the week. So in the interim, more time passes. The money is still missing. I follow up with auto owners, David Kaplan. I follow up with Kristen Yu of Chase Bank. I do all of these things to try to find out where this money is, because Ms. Boyd, instead of just responding and say, hey, can I just call my client and find out, we'll produce the bank statements, she tells me she doesn't have time. So then it's the next week. She ultimately responds, I believe, and I have printed out all the responses that she responded to. She basically says, here are 2 receipts, what she claims are receipts. Now, we had already filed the motion, and I had already filed and written to her the November 9th letter where I said, we've confirmed that the money was not deposited into the joint account. It was joint money. The UCC is relevant because you cannot go ahead and unilaterally sign checks that are made payable to one party and as opposed to or another without violating the UCC, and in this case, without violating the ex parte order that Mr. Roller and Ms. Boyd had entered. I wrote to her on November 9th. We've attached that as an exhibit. It's a very polite letter that I explained to her that the money was not deposited into the joint account. I asked, please let me know the information about where it was deposited immediately. It's large amounts of money. And then I asked her, I respectfully asking you to determine, one, into what account these checks were deposited and provide copies of the account statements showing the deposits. Two, disclose how any funds have been spent with documentation. And three, confirm that any remaining funds will be held in escrow in my firm trust account and not unilaterally dissipated. I put underneath, it's an underline, please accept this correspondence as notice that Mr. Roller does not have his wife's consent or permission to spend these funds unilaterally. I then let her know that I believe that Mr. Roller was in violation of the ex parte restraining order by unilaterally depositing and signing the checks with only his name. And I let her know, you've repeatedly stated in the past that our motions to show cause are an unnecessarily costly means of resolving the many financial issues I'm writing to try to resolve it without the need for a motion, but I need a response ASAP for obvious reasons. Once the funds are dissipated, they will not be easily recouped. I didn't get a quick response. I ultimately got a receipt, and this is after the motion has been filed, a receipt from Roto-Rooter, which says that on September 21st, $613 were paid by Mr. Roller to Roto-Rooter. I also got a statement that says from 911 Restoration, which is the mitigation company, that was paid on October 4th for $7,800. Those two statements were provided to me by Ms. Boyd after the fact, and I acknowledged that those things relate to the basement repair. Now, she also provided an estimate. An estimate is important, and I attached that, and she attached that to exhibits from Brent Tompkins, who gives an estimate for the basement repair of $38,200. The full amount of the insurance proceeds is $25,000. So if $78,000 was already spent, even if you can argue the $613,000 was already spent, $38,000 estimate is not viable. And it doesn't indicate that anything was paid. It's an estimate. There's nothing that she produced that indicates any payment. Now, I prepared for this hearing and I looked through everything, and the 3 checks that we had to secure from auto owners in order, and I do want to make this point. If Mr. Roller and Ms. Boyd wanted to resolve these issues, all they needed to do was be transparent. Mr. Roller could have been transparent and said, yes, I deposited them into this Chase account. I should have deposited them into the joint account. I didn't. Here, let me move them back. Or here are my bank statements showing where it was deposited, and this is how it's been spent. That never was produced. It was requested. We've had to subpoena it. And this has been now, how many? Like almost 6 weeks. That could have happened at any time, and it never did. And we've had to serve another subpoena on Chase Bank. Here's an important point, because the facts in this regard are pretty important. The 3 checks that came from auto owners that total $25,000. The first one was issued on October 6th in the amount of $3,890.81. The second one was issued on October 21st in the amount of $9,382.04. And the third one was issued on October 28th in the amount of $11,727.15. When you add those all up, you get $25,000. I confirmed with David Kaplan of Auto Owners that that is the extent of the policy limit. Now, that's $25,000, and no work other than the Roto-Rooter bill and the 911 restoration has been performed. Those 2 invoices that she did eventually send me had been paid prior to the issuance of either any of those 3 checks. Those were paid on 9/21 to Roto-Rooter, and Ms. Roller saw Mr. Roller pay it directly in the form of a check prior to the insurance money ever coming in. And then the 911 restoration was paid on 10/4, at least according to the documentation that they produced to me. So those 2 payments were made before any of the checks were even issued. And thereafter, there was $25,000 that came in that Mr. Roller put into an account in his name only. We had to subpoena Chase and go down this rabbit hole in order to find out that he ultimately deposited into his account in his own name ending in 0860. Now, for her to say and him to say, wait a second, you are unreasonable, you shouldn't have done any of these things, when I gave Ms. Boyd and Mr. Roller multiple opportunities to go ahead and honestly be transparent and come clean and say, yeah, you're right, it only has my signature on it. I shouldn't have deposited these $25,000 checks in violation and not providing Ms. Rebecca Roller the opportunity as that she requested, and she will testify today, that she signed them as well. He took all 3 checks. He signed them with only his name. We have those attached as exhibits. I can screen share them. I don't think there's any dispute. I don't know, though, how it would be disputed. And he deposited them into an account ending in 0860 with Chase, which does not have Rebecca's name on it. So those are joint insurance proceeds that were unilaterally taken by Mr. Roller and deposited into an account that he only has control over. So then we have these additional things that have had to happen. And I can't stress enough the amount of dancing around that I've had to do and the amount of work that's had to happen in order to get to the bottom of any of this. During any of this, Mr. Roller is the one that has access to his Chase Bank accounts. He could have produced statements from Chase Bank. She claims, and he claims through Ms. Boyd, that there are checks out there. I have never received a check. The only things that I have received, even though I requested account statements, transparency, the checks, how it was spent, the only things I have ever received is a rototiller or Roto-Rooter bill from 9/21 prior to the checks being issued, and the 911 restoration paid invoice that was also paid prior to the 3 checks being issued. So the details in this case matter. The details in this issue matter. Candidly, I know all the details and all the facts here. And for Mr. Roller to claim all of a sudden that Ms. Roller is in the wrong here and that somehow I'm some sort of rapacious lawyer who just likes to harass his lawyer for the fun of it is completely ludicrous. It is honestly gaslighting in the most extreme form. I've done nothing, and I will put absolutely every scrap of paper that I have ever communicated with Ms. Boyd in front of you, Your Honor, and there is nothing that I'm ashamed of. It is all respectful. It is all seeking a resolution. I just quoted to you my November 9th letter that I've attached as an exhibit. All we want here is to know where this money went. And candidly, we want there to be some consequences that Mr. Roller went ahead and took this money. He took this money knowing it was joint money. They had had a conversation about it. He only signed it himself, deposited it. Then he had noticed that there was an issue and he never provided transparency. We still don't have transparency. And I asked for all we need are the account statements and the cash checks, but we've never been provided them. And now we've had to issue another Chase subpoena to get them. It's still pending. Chase Bank is big. It takes a while. And throughout any of that, Mr. Roller could have gone to the bank. He could sit at his computer where he is right now and print out the bank statements through online banking and provide them. I think it's very telling that he has not done that. I also think it's very telling that no checks have ever been produced, copies of cashed checks. I think that the entire situation here would have been completely avoidable and entirely unnecessary had there been cooperation and transparency. I have asked and asked. I have very respectful emails stating specifically on December 4th to Ms. Boyd, stating, I sent you a letter on November 9th stating that Ms. Roller did not give permission for any unilateral spending, just like she did not give permission for the depositing of the 3 checks into an account that only Mr. Roller has access to, and which she was never given an opportunity to endorse. She is aware the remediation company was paid, and now, as of December 4th, agrees to this expenditure. And she saw Mr. Roller pay Roto-Rooter directly, not from the insurance proceeds, $613 on 9/21/24. Any other expenditures were not authorized per my November 9th letter to you, and on the basis that the checks were improperly deposited without her knowledge, and Mr. Roller was taking unauthorized unilateral actions with joint proceeds. There should be $17,200 remaining. $25,000 minus $7,800 to the 911 restoration, not $4,480.84. Where did the other $12,719.16 go? I asked for an accounting of spending in my November 9th letter and did not receive one, only invoices and the Tompkins estimate. No check or payment copies were provided. I am asking again now for this proof of spending. The Brent Tompkins company estimate is for $38,200, $13,200 more than the total proceeds provided. That's not affordable, and Ms. Roller would like to seek an alternative contractor. Then I ask her, please transfer the funds to comply with the court's order. They're already late. And please let me know if you will facilitate Mr. Roller immediately providing the requested accounting showing how the $12,719.16 of unaccounted for funds were spent. I honestly cannot understand why these things would be unacceptable, other than to cause otherwise unnecessary problems. So that's the math, Your Honor. And these earlier things were paid before the insurance money even came in. And we agreed after the fact that, okay, if he fronted that $7,800 through with money that he has somewhere, I assume his earnings, then we can credit that and have him paid back by the insurance proceeds. But with regard to the rest of it, there's still a $12,719.16 shortfall that remains. That money is missing. And that's what our accounting motion is asking for. It's saying, where did this money go? Now, obviously, had it been deposited into a joint account cooperatively and in compliance with the law, none of this would be an issue because Ms. Roller would have access to the funds as well, and presumably they'd be making joint decisions about how to spend it. But because of Mr. Roller's actions, which I believe were wrongful, here we are. And I'm sorry, and I do not apologize for trying to go ahead and hold Mr. Roller accountable for what I believe was a wrongful removal of these funds. I was never disrespectful to Ms. Boyd. I have everything in writing, and I'm proud to show any of it. And this could have been resolved at any time if there was simply cooperation and transparency.
Thank you, Ms. Whitman. Ms. Boyd, I'll give you a very brief response. I think you both laid out your positions quite ably on the record. We've taken a half hour to do so, but if you have a brief response, I'll allow it.
No, Your Honor, I don't want to waste the court's time. I think
I
the court
appreciate that.
understands.
Thank you. And I'm not going to be able to resolve the issues between the attorneys. That's something that professionals in this circuit and in this system are expected to be able to manage themselves. What I can do, however, and what I am concerned about here is the order of this court, which, based on the materials that have been provided thus far, clearly has not been respected. And I'm referencing the order that I signed years ago in this case. This is an old case. I signed it December 15th of 2023. So I said years, a year ago, that directed at item 1 that all parties were restrained from selling, assigning, transferring, encumbering, concealing, giving to a third person, to hold or disposing of any property of the parties without until further order of the court. This check was clearly the result of a damage to property that the parties own, that is the primary asset in this marriage. We've had a great deal of discussion regarding this asset, and there was damage as the result of an insurance claim, or I should pardon me, that's incorrect. There was an insurance claim as the result of damage that resulted in a payment on a policy in the amount of $25,000. That $25,000 was titled to both parties. The order that was in place since December 15th of last year was clear that assets of the marriage, which would include certainly a check drawn to both parties, had to be treated in a manner that was consistent with the order. And by the defendant depositing that, whether his intentions were good or not, depositing that on his own into his account without the signature of his wife, and apparently expending what had to be, I assume, some kind of marital resource in advance of that in order to cover 2 fees, this Roto-Rooter expense of $613 and the 911 restoration expense in the amount of $7,800, and then presumably paying himself back, which would have been entirely appropriate, or paying the marriage back, frankly, for those expenses, which would have been entirely appropriate. By him taking those actions without the advance knowledge of the plaintiff is in clear violation of my order. And what concerns me about this entire case is the lack of respect that the defendant in particular seems to have with regard to my orders. And it couldn't be any more clear, frankly. It just simply couldn't be any more clear. The defendant took this upon himself without communicating with his wife regarding the manner in which the monies were to be deposited, and in doing so violated my order of December 15th of 2023. I think these parties need to understand, and defendant in particular, that until a divorce order is entered, their assets are under ultimately my control and disposition. And that's the result of our system and of the type of complaint that they have made, which is a divorce complaint, which separates their assets equitably between them. For me to be able to accomplish that, I have to have control over those assets where we have disputes like we have in this case. And I'm not going to go through all of them, but they are multiple, and they have not been certainly by this point fully resolved. So I remain concerned about where the resources remaining from the expenditures, that is the money that Ms. Boyd has in her IOLTA account, plus the expenditures for Roto-Rooter and 911, where the additional $12,719 in change is located. I'm concerned. I'm concerned about that money being in the sole possession, at one point anyway, of Mr. Roller. I'm concerned about that because I don't believe that he has been compliant with regard to my order as it relates to the joint disposition of those assets with court approval if required. It does appear to me that he has been skirting that order in order to advance whatever interests he has. Clearly, if he had the money available, it would have been included in the monies that were ultimately given to Ms. Boyd. It appears to the court he does not have that money available. And if it is, then that should be explained to me. But these are the concerns that I have with regard to the status of the $25,000. It is frankly a contempt of great hubris to my order to take $25,000 that came into the marriage and dispose of it in the way that one party wishes to. And it is the kind of contempt, frankly, that justifies, to the extent we don't have information regarding the location of the additional $12,700, justifies among the more severe kind of penalties that this court has. Mr. Roller needs to understand, and I've explained to him before, that I do have powers that I can use in a situation involving contempt. We can talk about criminal contempt. We can talk about civil contempt. I don't know if this is a criminal contempt matter, but it certainly is a civil contempt matter. And I can hold him in jail until such time as he finds the $12,719.16 or provides an accounting regarding same. The only thing that is stopping me from doing that is the fact that Ms. Whitman has filed a motion, but the motion hasn't been heard yet. Ms. Boyd hasn't filed a response. This motion just came in. But I certainly think the parties are well aware as to how I'm going to view that motion. It would make a great deal of difference to me, frankly, if I knew that there was resolution regarding these additional marital assets in terms of their location and disposition. And if the defendant used them for some other purpose, well, he needs to come clean and explain that, and then we will deal with that in the course of events. But leaving $12,719, half of the money, essentially, that came in out there in the wind, without the plaintiff knowing where it is, the plaintiff who, by virtue of this court's order, should be involved in every step of the disposition of those assets, is of significant concern to the court and is placing Mr. Roller in terms, in jeopardy of his freedom. So let's do this. I'm going to reset this matter to conduct a hearing on Ms. Whitman's motion. I've already told you what I expect that result to be. Perhaps Ms. Boyd will come and tell me that I've completely misinterpreted the situation, and I will certainly listen to her if I have. But based on my review of the materials, what I've told you today is the way that I see this situation shaking out. And when we do have this hearing, I'm going to expect that prior to that date or at that date, we will receive an explanation or identification of where those funds are. If we do not, Mr. Roller should bring his toothbrush, because he will be spending some time in jail until such time as we actually find out where that money is. I'm going to require that this hearing be held in person, and I'm going to have an officer here ready to take Mr. Roller into custody if necessary to exercise civil contempt against him. All right. Have I made myself clear with regard to the information that we need prior to the next hearing that we're going to conduct? Let me start with you, Ms. Whitman.
Yes, Your Honor.
All right. Ms. Boyd?
So just so I can write it all down and be very specific.
Well, we talked about a lot.
Yeah. So we need an accounting of where the funds went, minus the 4,000 whatever it is that will soon be in Miss Whitman's IOTA. We need bank statements showing those, as well as canceled checks if payments were made by check to various people for any repairs. Is that sort of my understanding?
I am hopeful that all of the money went to repairs. And if that's the case, then we need to see proof of that. If it did not, then we're going to have to deal with that separately. If the money was used for some other purpose, we'll have to discuss that separately, certainly. But all of that will need to be provided prior to, or let's say prior to the hearing that I expect we will have probably in the next week to 10 days.
Okay. And then I can provide that to both Miss Whitman and just the the general 13 Circuit Court admin email so that everyone has that beforehand? Or should I just bring copies with me since we'll be in person?
Well, you haven't filed a response yet, so my
Okay.
expectation is this would probably be an exhibit to the response that you file.
Okay. I can do that for sure.
And with regard to the motions that have been brought today, we've already gone through the objections. The objection with regard to, defendant's objection with regard to the return of the insurance proceeds, that is overruled. Ms. Whitman, if I could get an order from you on that.
Yes.
The objection to the ex parte order for return of insurance proceeds and placement of proceeds. Ms. Boyd, did you have any additional argument regarding that, or based on my discussion today, do you need additional argument?
I would just say honestly, my objection was just based on the amount. The parties obviously did agree to those expenses for Roto-Rooter and the $7,800 for the 911 restoration. It's admitted by Ms. Whitman in correspondence. It's not the holding of the funds, it's the amount. I mean, I provided proof that my client paid those monies to those various to contractors. So I don't know how he can turn over $25,000 when the parties did agree to those expenses. So it's not the holding of the funds, it's just simply the amount that the objection is based on.
All right, Ms. Whitman, any response?
I think I have to repeat my point that those funds were spent before any of these 3 checks from auto owners were ever issued. So those money came from, according to the checks and their dates. Ms. Roller saw Mr. Roller write a check prior to any money coming from auto owners to Roto-Rooter in the amount of $613. And then the $7,800, the only thing I received from Ms. Boyd and Mr. Roller is, and I have a copy here from 911 restoration stating that $7,800 was paid on October 4th. So if they had if anything else, I mean, I've been asking, like, please Mr. Roller's shaking his head, but he has sole control over his own bank account and could have produced anything up until this point other to show that those funds actually came from the auto owners. What we should have known and seen and have been provided to us way before now, given his unilateral action, is, hey, I paid this $7,800. The check came in. The first check came in from auto owners dated 10/6 for $3,890. The second check came in at 10/21 and $9,000. So there wasn't even $7,800 to pay from auto owners until 10/21. And
But it was my understanding the insurance
Hold on,
company
Ms. Boyd.
required that.
Ms. Boyd, please. I promise I'll
Oh,
let you
I'm
speak
sorry.
again. That's all right.
Sorry, my internet just stopped for a sec. I think I froze.
All right. Hold tight. We'll get to you in just a moment. Continue, Ms. Whitman.
So when you look at the actual dates of the checks and when the money came in, we haven't been able to access the bank account that held this money because we had to go through all the subpoena information, and Mr. Roller has never produced his bank statements. We're waiting for Chase on a subpoena.
Ms.
That begs
Whitman,
the
let me
question.
stop you for a moment. How are
Yeah.
we doing on payment of the taxes on the property? Have the taxes been paid up?
Oh, he's paid nothing. No.
How do we have $7,800 in what it must presumably be marital assets sitting around and not being utilized to pay taxes that are outstanding?
Well,
Anyway, that's
a
a
$1 million
side issue.
question, and there it is. But
Ms.
we're
Whitman,
trying to
please
get
continue.
transparency with regard to the bank accounts that this money went into. He has sole control over it. He could have given his lawyer copies of his bank statements at any time. I mean, this is a game. That's what this is. And to think otherwise is to be a fool, because that's what this has been the entire time. And I have to dig and get the information and show how the money actually goes. And then I'm stuck spending all sorts of money trying to get the information from Chase Bank when Mr. Roller could just go and log on and print it all off. So With regard to the $7,800, as I said before, we don't have an issue after they produced that. And Ms. Roller said, yeah, they did the remediation work. They did a good job. But the reality is the $25,000 that should have been in her control too didn't pay that initially and didn't pay Roto-Rooter. So the money did come from somewhere, and it's money that Mr. Roller has that he hasn't been utilizing to pay the taxes by continuing to claim that he has no money. Just like he just told my client that he paid spousal support that he never paid. And just like he just told my client that he bought all these Christmas presents and gave her no money to buy Christmas presents until $300 on Christmas Day when he bought himself and all the kids all these presents. I mean, this is real. And this is what we're doing here, unfortunately. So,
All right, let's not go too far afield. I appreciate the additional information, but we don't need to get into it, Ms. Boyd. At least not today. I'm really concerned about the $25,000. Did you have anything else that you wanted to speak to on that point?
Well, I'm blown away now that we're talking about Christmas, because
And I
I think the
asked that we
court
not
knows this.
go there.
Yeah, this is awful, frankly, but I'll leave that for another day. But
Please.
this is the kind of stuff that Miss Whitman loves to do, is just throwing a jab right at the end, right? So it's a great time to defend against stuff like that. Nonetheless, I can provide bank statements. I just received some from my client yesterday, but it's my understanding that in order to receive the insurance proceed money, you have to show you actually have costs and repairs that are necessary to get the money from the insurance company. So it makes sense that my client would have estimates or would have something from 911 restoration or Roto-Rooter beforehand to submit to the insurance company to be able to get the money. You can't just go to the insurance company and be like, oh yeah, it just flooded. I don't know. Can I just have like $25,000? No, you have to have something from a professional showing that work has to be done. If I didn't actually provide the receipt for Roto-Rooter or for 911 restoration, I do apologize. There were two different ones for 911 restoration. And I think I missed that in my email that I sent to Miss Whitman. But I want to also make clear, I also sent Miss Whitman pictures of the home, and it is tore up halfway up. All of the drywall is tore out. We're not talking this was just a little flood, Your Honor. We're talking halfway up the wall. It's all tore up. And now Miss Whitman wants to put a hold on these proceeds. And I don't disagree that my client signed those checks and they were not deposited into a joint fund. That is not in dispute at all. So all I'm saying though is the actual $25,000, we do have expenses that I have shown Miss Whitman in good faith in an attempt to resolve this, the receipts for those expenses. But again, it's not good enough. I just got bank statements yesterday from my client for November, because again, Chase Bank doesn't do statements necessarily on the first of each month. He can't go in and necessarily print them off. You can't take a screenshot. So he has the statements. I just got them yesterday. I will forward to her what I have. But I did produce what I had, including pictures of the marital home, of why those expenses were necessary. She even admits to her client that they were necessary. But again, you can't just walk into your insurance company and just magically claim that you have all these expenses. You have to produce something in writing. I'm assuming that's what took place. That's why there's a delay in the timing. And if the court and Miss Whitman were able to actually hear my motion to sell the marital home, which I've been asking the court to do for months now, this wouldn't have been an issue. My motion to sell the marital home is still pending. These parties don't have the funds to continue to maintain a home this big, and my client continues to be punished no matter what he does, whether he pays the taxes or can't pay the taxes. If he pays the taxes, then he's punished because he didn't pay enough. If he doesn't pay the taxes, he's punished because he's not doing anything as it relates to the mutual restraining order as to assets. It's a lose-lose no matter what he does. And now we have this flood situation that has caused even more additional litigation. It never ends when it comes to this house. And frankly, if the court were to grant the request to sell the marital home, the parties would actually have funds to be able to go and be separate, live separately. But that hasn't happened either. So we're stuck in this constant battle all the time. It makes
All
no
right.
sense.
Let me stop you there because you're now introducing an issue that we haven't talked about in some time.
You're
This
right. I
case is a year
apologize.
old. Well, that's all right. I just I get a little concerned when I hear that a motion hasn't been scheduled. Would you do me a favor and please communicate with our office and ask that that be scheduled? I recall discussing this at one point and indicating that I would allow this matter to, I think, remain on hold or take it under advisement, if I recall correctly, and take it up at an appropriate time. And we may be getting to an appropriate time. If you'd like to have it taken up, then just ask. We're not intentionally trying to quash a motion without it being resolved. So you are absolutely welcome to do so. And frankly, I think some of your argument regarding sale of that asset is something we're going to have to discuss at this point. But regardless, let's figure out what happened to $25,000. I am going to, with regard to the objection to the ex parte order for return of the insurance proceeds and placement of proceeds, Ms. Whitman, to the extent that order identifies funding and expenditures, I think that perhaps it can be revised to indicate that the amount of the proceeds was $25,000, that there were checks that were written prior to the receipt of the funds in the amount of $613 to Roto-Rooter, $7,800 to 911, and that it can also be modified to indicate that Ms. Boyd received the amount of $4,480.84 in her client trust account, which she is now transferring to you. So if you could modify that order to specifically indicate those amounts. Yes, Ms. Whitman.
May I get copies of checks that showed that those funds were actually spent? I mean, we don't know
Oh, I
where.
thought there was agreement on that. Okay.
No, I have no idea. All I received were the invoices from Roto-Rooter that says paid, and then the 911 restoration invoice that says paid. I don't know where that money came from. Like you said, $7,800 that came from somewhere.
All right. I'll leave it to Ms. Boyd to come up with the actual drafts so we know where that money came from. And that's entirely appropriate, given that they must have come from some marital asset somewhere, or at least putative marital asset, to the extent that we're talking about a business asset here. So let's go ahead and provide that information along with the other information that I've already discussed for the next hearing. And because of that, we'll go ahead and put the objection to the ex parte order on hold, and we'll fully address that then at the time of the next hearing. Is there anything else that we need to address then today, starting with you, Ms. Whitman?
No, the order on the objection will be put on hold, so I won't submit that yet until we come to you in person at the next hearing.
This is regarding the ex parte objection. The order regarding submission of the plaintiff's interim order, I've already overruled. That should be signed by the court.
Okay, yes, thank you.
All right. And anything, Ms. Boyd, until we meet again?
No, Your Honor.
That wasn't representation. It was finger-pointing and one-upmanship, leaving the actual case in the dust. The attorney seemed more interested in trading blows than actually resolving anything meaningful. But what do you think? Did this even resemble a legal dispute by the end? And if your attorney acted like that, would you be asking for your money back? I know I would. Let me know your thoughts in the comments. And don't forget to like, subscribe, and hit that notification bell for more gripping courtroom moments. Thank you for watching. See you in the next one.